Hello everyone.
Hello everyone, I'm Bhavani Kalaria.
My name is Kishan Bhatt.
Welcome everyone to our fourth live legal news update, and we're looking forward to speaking and talking generally about the general data protection regulations.
Yes.
And maybe having a general catch up on what's been happening in the last month since the last.
There's been quite a few updates, employment tribunal fees and things like that. It could be good to share the news with you and talk about.
So there's been a lot happening, and I think also just on the firm front, I know you did a lunch and learn recently at WeWorks, which is quite good, and I did a Brexit orientated FSB meeting, so it's been a very busy month. But I guess we might as well get started, and why don't we start with the GDPR?
Sure. So this is the General Data Protection Regulation, which is going to affect a lot of people. It's an extension of the Data Protection Act, and effectively it's really protecting our personal data and how it's been used and utilised. So I know you've got a few things that you've looked at. I've looked at a few articles as well. There's quite a lot out there, but it is going to impact a lot of businesses.
I think most people will have seen a fair bit in the press, whether it's the legal press, financial press, or other business kind of press, about this. And the reason is because it really is going to affect all businesses. So if you are dealing with customers or consumers or dealing with people's information, it's extremely important that you have a handle on the changes that are taking place. But as Kishan mentioned, as you were saying, this is an extension of regulation that we've had for a while. I think the difference is that it's much deeper. And I think there is, the impression I get is that it really is requiring people to take seriously the procedures that they have internally in managing information.
And to protect that data and make sure that it's quite secure. And it's also taking a step further and making sure that it's compliant with sort of the modern practices of businesses. So looking at technology, looking at the websites, IP addresses, which we know we'll go through with you today.
So look, why don't we try and kind of work through it in systematically. It might be helpful for people to understand one of the key sets of definitions in the new regulations, which is controllers versus processors. Maybe if we can explain that a little bit.
Sure. So the starting point, what I want to mention before we begin actually, is that this legislation on data protection is effective from 25th of May 2018. So that's when it comes into play. So you need to be ready, the businesses need to be ready by that date. That's 25th of May 2018. So like Bhavani said, there's a difference between controllers and processors. So controllers, data controllers, say how and why personal data is processed. And so it means the person who determines the purposes for which personal data are to be used. So that's a data controller, the person who looks at data. Then you've got a data processor, and a data processor is a step beyond a data controller, and that's in relation to personal data, who processes the data on behalf of the controller. And so how it's used, so the processing of that data, and that could be obtaining data, holding it in storage, recording it, organising it, adapting it, disclosing it, deleting it. So it's actually someone who's physically doing something with the data, or a business that's physically doing something with it.
And I think the other thing, I think on a macro level to get across to people is that it's not just about then, how are we processing it, but this legislation comes with rights. So what they're effectively saying is, look, if you have an individual's information, that individual has certain rights, and those rights are a little bit more extended than they were previously. And there's a list of rights that people will have now, and those include things like the right to, obviously access your information, right to erase your information, and a right to effectively be able to control your personal information,
and how it's used.
Requirements for explicit consent. And those type of things. And how do you think then? How do you think that changes the way that businesses should look at kind of data control?
Sure. So like Bhavani said, that the rights are a bit more extensive now, and as a result of that, what the GDPR, the new legislation, has done is placed more stricter, specific legal obligations on processors. So now they're actually required to maintain records of personal data and actually maintain records of the processing activity, so how the personal data is to be used. So businesses now need to document exactly how they're going to use it. And if they don't do that, if they don't follow that simple formality, then that could mean a greater legal liability to the processor who will be in breach of the regulations. So that's quite fundamental and important. But what's really important here is to see if your business or if you as an individual is caught under this, what the definition of personal data actually means. So that's quite important. So the Data Protection Act went to some extent to define what personal data means, but GDPR has gone a bit more beyond that, a lot more broader, so it catches a lot more things now. So for example, personal data now includes what they call online identifiers, so and location data. So things like your IP address, your mobile device ID, and all that kind of technological stuff has to be protected accordingly.
So, I mean, look, so we've got, hi, hello, my dad's joined and so my son. And we've got a couple of questions. Well, we've got a question which is about, would this only affect email marketing? And let's talk a little bit around that. So, okay, so we've talked about really why this has come into place and what it can cover. I mean, I guess it would be helpful to know exactly who would be caught. In my view, I think pretty much any business is caught. I don't think and to answer the question, I don't think it's simply about, saying there's a whole load of stuff that only businesses working online have to do. But I think there is an offline and online kind of responsibility.
Of course, yeah. Yeah, I mean, it's an extension, we can't forget that it's just an extension of the Data Protection Act. So any data is really caught with this. So businesses that have data will need to follow the GDPR. But it just goes a bit more beyond the definition of personal data, goes a bit more beyond what was already captured under the Data Protection Act. So, I mean, things like what they use the term pseudonymous data, which is a bit of a mouthful. We tried a few times before this to try and say that word, but I think we're getting there now. So in simple terms, that what that means is personal data that's subject to technological measures, so things like hashing or encryption, that would be caught under this. And what the GDPR has done actually is it's encouraged businesses to use pseudonymous data because that enhances the security protection for that piece of data. So it's quite important that to limit your risk, to limit your liability, you want to try and pseudonymize it as much as you can.
I think what I'd like to do is because hi Mitch, thanks for joining.
Hi Mitch.
So I think what I'd like to do is maybe so that people who are watching, rather than kind of focusing too much, I guess, on the detail of the legislation, perhaps if we can talk about the kinds of things that the Information Commissioner's Office will be looking at, which is effectively going to be the supervising body for this, in terms of data handling. That's the first thing. And then maybe secondly, just go on and talk a little bit about how breaches might arise and how they might deal with them.
Yeah, sure.
I mean, I don't know about you, but obviously the first and most important thing is to be able to identify where your customer's information is being held and make sure that the process is in place to make sure that that's safe.
Of course, yeah. That's a great starting point to making sure that your data is held, having a good sort of a spreadsheet or whatever you have to monitor what data you actually have. And then you can take the steps of pseudonymizing it if you can do that, and the other steps. But the GDPR now has placed some compliance rules that companies have to follow. So in terms of what the ICO want you to do is the first thing is put someone in charge of in the business to take care of this data, and they call that the data protection officer. So this person is responsible for defining your procedures and ensuring that you're compliant. And this person needs to sort of have the awareness of the rules and also train people within the company about this compliance and procedures. And so, we were really looking as a firm to hopefully provide that training to these people to see how they can be compliant and how they can deliver that service to the company. But it's also a person who you would go to if there was a complaint about a breach of any of the rules. Then the data protection officer is the first sort of port of call for that.
I think so. That's a good point that you make. And hi, Amit. Thank you for joining.
Hi, Amit.
Is that obviously the first thing that any company can do is put someone in charge of overseeing this. And I think that, and please, people, do ask your questions and share any comments that you might have or any observations that you might have on this area. But one of the first things that any business can do is put someone in charge and then have an overview, an audit of what's going on. And I think what they're really looking to do is now is get businesses to take on board and, I guess, take active steps to mitigate the risk that there might be leakage of information. And so long as you are doing these things, it's not just a tick box, but it goes some way to show whether or not there's been material damage done. So I think one of the things that struck me when I was reading this is that we knew under the previous regime, so to speak, that there were financial penalties. But I guess now what they're saying is, look, there will be compensation that's payable, but it needs to be, but there will be this requirement to show that there has been some damage done. And so as a business, I guess it makes sense to say we've done all of these different things.
It's a checklist.
We've tried to limit the damage. And these are the processes we have in place in case there is a breach.
Exactly, and so that follows nicely onto the second thing you need to do, and that is to make sure you have the right procedures and check your procedures. So the GDPR now requires documented procedures for quite a lot of things. So, for example, defining the sort of legal basis of you using or acquiring data and why you need it, delivering sort of privacy notices, and also getting explicit consent when it's required. That's really important from your customers or whoever it is, and also managing access to that data by other users, and that could be, for example, employees, because you're going to hire staff and they're going to have access to sensitive personal data sometimes, and personal data depending on the nature of the business. And so your employee handbook and your HR procedures need to be really carefully in place, because if the employee breaches it, then the company breaches it, and the company is responsible and liable for that. So it's important that everyone gets training, not just the data protection officer, but the staff that are handling data as well. And so it's important to also review contracts between suppliers, between customers, to making sure that that if you're passing data for any reason, it's done correctly.
I think that's a very good point, because the other thing that I was because quite often people go, well, we're not doing that much. It's fairly straightforward. We're just taking, we'll get our customer information, we keep it safe. But it's also then that secondary step of saying, who am I dealing with? Which I think people sometimes miss. That's important. And I think you touched upon a couple of things, which is the first, which is the explicit consent. So I think there's been a move away anyway from this, but not just having a tick box to say, kind of like a negative consent, but having a proper positive consent with with plain English language so that people understand what they're consenting to, I think is going to be important. So if you do have any terms and conditions that need to be updated, it's well worth doing that.
Now it's a good time for you to review your contracts and also try and have a very good procedure in place, because like we said before, it's about having a checklist, and if you're going to get caught in this, you can get caught very easily in this regulation by not having that in place. I think Khalid's made a question. He said,
where can I get more info about the GDPR regime?
Yeah, good question. Well, your first port of call is obviously the London Law Practice.
But the second port of call will be the ICO, the Information Commissioner's Office. Because actually, you know what? That's without a shadow of a doubt, that is the place to go to, I think, to kind of understand the regime as it is. I mean, most businesses we're registered with the ICO because obviously we handle people's data. So, they have a whole lot of information on there about what the different changes are going to be and, what steps to take. There's a checklist of what businesses can do to update themselves.
Yeah.
But obviously it's well worth, as Kishan was saying, to make sure that you've got people who understand the regime and how to apply it.
Exactly. Yeah, and that's where we can help.
That's where we can help.
But it's, the GDPR has also created quite strict requirements. So one of them is responding to customer complaints within 30 days. So you have 30 days to respond to those complaints. If you don't, you're in breach, and that could result in a fine. If you want to share or erase customer data, then on request, then it has to be done. So if a customer requests you to delete it, it must be done. Keeping records.
Although I think that on the erasure point, I wonder whether. There must be some way of being able to come out of that, because I guess, for example, with lawyers, we have a requirement to make sure they were holding information for 6 years. So it may well be worth. I think that I read that there's the right to seek erasure, but there might be subject to certain exceptions. Yeah,
there has to be, I guess, a reasonable reason for that, and then we need to explore what that reason is, and if it's reasonable to do so, then we can perhaps look into that and caveat it. There's also other obligations, such as keeping records of who sees which data and reports any breaches. The breaching report, it has to be done within 72 hours, which is very, very tight. So there's quite a swift approach that needs to be used. The other sort of recommendation for businesses is sort of defining a governance structure for the business to ensure compliance. And that's to ensure that you keep your processes up to date with all the changes and technological changes that take place. So that there's something called privacy impact assessments that you can do, and you can have it on file. So if there's some new data you've got on board, then create a sort of a flow chart where how you're utilising that data, how you're storing it, how you're using it. That could be a privacy impact assessment, and you can place that on file to protect your business. And again, it's a checklist.
Yeah. So I guess the other thing we need to that people may well be interested in is that we've talked a little bit about the breaches and damage and the type of steps they could take, but. What if someone... So this is something obviously we face. We've got clients who have subject access requests of some kind or another. Yeah. It is quite often, if it's a small business, an administrative burden. Yeah. And I can see that in these regulations, there's no fee that... Before you used to be able to charge a fee for the access request. So what's happening around the fees?
Yeah, I think that there's been some changes around the fees. I think it's now has to be sort of proportionate to what you're dealing with.
So
it's proportionality test.
So basically, I think what the regime now is that there isn't a fee that the business can charge. Yeah. But if there are excessive, disproportionate requests, then there is an argument to say, look, we can charge for administrative time. Now, I don't know. I think we'll have to see what they're looking at when it comes to disproportionate, but I would suggest that one of the things it could be repeated requests for that could verge on being vexatious, or repeated requests of the same kind of information would probably fall into that.
Would fall into that.
So that's the fees. I think that the other thing I kind of wanted to talk about on the data protection side is that we've talked a little bit about what businesses have to do, but the other positive thing, I think, and I was reading an article about this, is that America, for example, is doing away with legislation that helps keep people's information private and secure. Whereas over here, we're going in the opposite direction. And, I don't know about you, but although from a business point of view, it seems at this point in time that there might be a lot more that needs to be done, the argument is that it's going to improve the way that businesses do business and improve people's trust in business, especially online.
Yeah, definitely. Especially online, there's a lot of nuisance calls that we tend to get quite a lot of. A lot of the times, we try and get them to remove us from their database, and I still get the same calls.
Yeah, I think I've heard you say,
take me off your database. It doesn't always work, so it's really going to help things like that. So I think there is a positive move. I think if this can be managed effectively and everyone knows how to comply with these rules and regulations, then I think it's a positive thing for businesses and for consumers as a whole.
Yeah, I think so too. I mean, as we've been saying, if people have any questions about how to apply the new regulations within their business, or they need to update the handbooks or look at the terms and conditions, obviously we'd be very happy to speak to you about that. And if you needed to get training done for your staff members also. I mean, I don't know whether there was anything else that you wanted to pull out of it. I mean, I know we talked about the biodata and...
Yeah, that's right, So I think so again, going back to defining what personal data actually means, there's also another definition of that's caught in this, and that's genetic data. So an individual's gene sequence and biometric data, so your fingerprints, your facial recognition, so your scans, that's all being treated as sensitive personal data under the GDPR. So large-scale sort of processing of genetic data, usually, I guess, would be research labs and places like that. They would trigger a requirement to have a very strict data protection impact assessment to identify the potential risks. So there's that requirement for those kind of houses.
Yeah, it's quite interesting because I think that whether people are working in really cutting edge, high tech, organisations where they're looking at genetics, or whether you're running an offline business that is selling a product through a shop, everyone will have the same responsibility. So as I think we were talking earlier, if you have a physical file, and you leave it somewhere and it's not secure, that's a that's a breach. It would have been a breach anyway under the old regime, but it remains a breach. So
remains a breach. But actually, from that example, if you don't have a procedure documented to deal with something like that, so if there's a likely consequence of leaving something somewhere, and it's not documented about what you would do if that happens, then that's an extra sort of bit of non-compliance with the regulations now.
Yeah. So. Do you know what? Shamila's just said a lot of impact for the Home Office then, because all visas are biometric now. Yeah. Really interesting because actually there was a case. Do you know, we were talking about it just now. Basically, there's just recently a judge's notes have been disclosed under a Data Protection Act request, subject access request made under the Data Protection Act, and they were his handwritten notes. And the reason why it kind of ties in with what you're saying, Shamila, is that because what the Ministry of Justice said was these are not covered by the Data Protection Act. And effectively what the DPA, with the ICO, when they were enforcing this, said was that actually the fact that they were written on is not what made them personal to the person about whom the judgment was being written, but the fact that it was put on the court file as soon as it became something that was part of a kind of a cataloguing of information that gets caught. So it's a relevant filing system. So I would suggest that the Home Office obviously would then, because of the way that it's filing its information, would be obliged. And I think that public authorities are going to be having to...
Just going back to Shamila's point, the GDPR does have sort of caveat clauses in there where it doesn't apply to certain activities, which include processing covered by a law enforcement directive, and that could be, I would presume that might be protecting that. We need to look into that. But there's also other things like processing for national security purposes and things like that. So that's when the GDPR won't apply, and there's protections for that.
I guess what they want to do then is that they've said the higher the interest is the national security and then your rights. Yeah,
and just for our viewers out there, actually, just one point there, the GDPR doesn't apply for processes carried out by individuals for personal and household activities. So if you're just doing it within the house and for personal use, you won't be caught, so don't worry. You won't need a procedure.
Yeah, so Amit, has said there is authority to have judges' notes outside ICO. That's right. So that's exactly what happened. But then what's happened subsequently is that it might well be the same case. I don't know, but the ICO then found that it's still, those notes, handwritten notes of the judge, when placed on the court file, would then fall within the data protection kind of coverage. And if someone made a subject access request, they could have them. I mean, the commentary I've read suggests that the ICO has described this particular decision, which was the early part of this year, really, late last year, early part of this year, to have far-reaching effects. Obviously, it may well have the effect of dissuading judges from expressing themselves freely in their notes. That's the other effect it could have. But very interesting kind of area for lawyers to think about.
Yeah, it is quite interesting.
Don't know, should we move on?
Move on, yeah, let's move on. I hope that's been useful for our viewers. I guess we can move on to employment tribunal fees.
We could do that.
Yeah, we could do that.
If anyone has questions, please send them through. Yeah, so employment tribunal fees.
Yeah, so big news, really big news. Employment tribunal fees are now no longer in existence. The Supreme Court have overturned the decision by the government to impose tribunal fees on employees wanting to bring claims against their employers. This now means that employees can bring claims against their employers without having to pay a tribunal fee. So there's a fee up to around £800 to £900 for actually the whole claim in tribunal. That's now abolished. And it also means that those people that have paid tribunal fees already could retrospectively claim back those fees that they've already paid out to the tribunal office. So,
a couple of things just so that we can do a shout out. So our colleague Bazade wrote an article for the Law Society Gazette. So that's up on our Facebook page and other social media, so do read that. But I think, as you were saying, really important and interesting case. Basically what the court said in that was, look, for people to have access to justice, there needs to be a consideration that the courts need to sometimes get involved to be able to give access to justice, and they found that actually these tribunal fees were impeding that.
Yes.
And the second thing that you said, which was if people have been dissuaded from making a claim before?
They can do so now. I mean, one thing you have to just bear in mind that there are time limits on bringing a claim. So usually the normal rule, and there are exceptions, is 3 months from the date you're dismissed, or 3 months from the date that something's happened, such as a discriminatory act. So as long as you fall within those time limits, then this is a good time for.
But we had an internal discussion about this, and many of the lawyers kind of joining in now, about whether or not, even in those circumstances where someone has now missed the time limit but didn't bring a claim because they couldn't afford to do so, there may be an argument to say actually now they should be able to go back and look at that, especially if the decision that they made was based on the fees. Now sometimes it's difficult to prove that because there might not be a note, you don't know exactly, but really if there are people who have done that. The second area I think we talked about was settlement agreements.
Yes.
Was whether or not someone had agreed to a settlement, partly persuaded by the fact that there was a pretty significant tribunal fee to be paid. It is interesting. I mean, these are potential test cases for the court, but I think both are arguable. With the settlement agreement, the only issue you would have is that you're independently legally advised on that agreement, and sometimes the settlement agreements will have clauses to say what applicable law applies in that agreement. So if it says something like only the law enforced at the time applies, then you may be more difficult. So worth maybe checking those settlement agreements and going back and looking at them. So I think that was the other big news this time. I mean, I've pulled out a few other things that I thought might be interesting to people. They've not made the headlines in the same way the tribunal fees and GDPR have, but there is talk at the moment about kind of making the conveyancing process So look, there's an article in the Royal Society Gazette which is headed "End of Wet Letter Day." So essentially, most people who lawyers will know that important documents like your wills, your transfer documents for your properties, by and large, have required a wet signature. So a hard copy wet signature saying this is I agree to this. But now there are the land registry is taking steps to try and automate it so that you can avoid having to write, have a wet signature. And the way they want to do it is by using publicly available data to corroborate someone's identity before that signature is made. Such an interesting thing, given what
the GDPR.
The GDPR.
Yeah.
I don't know how it's going to work, but
they could get caught in that quite easily, couldn't they?
Yeah.
From what we've discussed, especially if they.
Yeah, I wonder whether people would have to give explicit consent to allow the land registry to access different, publicly available databases
to
do
a way
that.
around it. Yeah.
Quite interesting.
I mean, it makes sense though using technology to kind of help the processes, and especially with the land registry, they've already got kind of a whole database of all properties and storing data on there about information about the property. You can download documents about a property from there as well. So it's good. It's good that it's taking it a step further.
Yeah, not just that, but also, and I don't know whether this will ever happen, but having digital signatures for wills. I mean, we see some contentious probate stuff, but that would have to be really watertight.
That would be,
so maybe some way away, digital signatures. But I thought quite interesting, given where technology is taking us, but also where where consumers' rights are going when it comes to that space.
Yeah, I think digital signatures for wills would be quite hard because if it's contentious, then usually you get a handwriting expert to see if they've actually,
signed it themselves and all those things.
Yeah.
I mean, I think unless people have, it'd be great to have some questions. But otherwise, I think we could probably summarise today's
definitely
session. I mean, I think I don't know about you, Kishan, but from my point of view, I think it seems to me that the law is now trying to catch up with lots of the technology, essentially, and I think that's both in how we draft our documents and sign them off, but also what happens to our information. I think it's been very easy for people to sell data, and that's being addressed now.
No, it's true. Yeah, I do sometimes watch debates in Parliament and the Lords, and I've seen sort of our politicians focus heavily on technology and the changes when they're actually making the law, and even judges are they've got that in mind when actually creating the law, if you like. So it is important because we need to keep up to pace with all the technological changes. Otherwise, we won't ever do that. So
it's quite. I mean, this is a really big topic because we could talk about Twitter and all sorts of things. Defamation online and all sorts of things. But
and it's like where does the line end? All this. You can go on forever.
Yeah, but I think as I said, if people have any questions on the GDPR, how to apply it, in compliance, anything like that, please do get in touch.
Yeah.
Anything on the employment side or...
Yeah, absolutely.
Indeed, any of the things we've covered previously.
Yeah, definitely. Let us know. And if you have any suggestions about what you would like us to talk about, and as long as we're comfortable with dealing with it, then we'll be happy to talk in our next episode.
Yeah. So look, thank you very much.
Thanks for joining us.
Take care. Bye-bye.
Have a good evening. Bye.
Bye.